rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. We're here for oral arguments in cause number CV17-0518, Nicaise versus Sundaram, and I apologize if I've mispronounced anyone's name in that. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we've read the briefs and have discussed the case in conference. At this point, counsel, you may proceed.
Please the court. Good morning, Your Honors.
Good morning.
I'd like to hopefully just use 10 minutes for my opening and then reserve the rest. I'm here with my co-counsel, Matthew Monaco, who is on the briefs with me and assisting me. My main theme for the first issue I want to talk about, Your Honors, is rant does not equal harassment. And the trial judge in...
Just as a matter of law? I mean, can't you go on a rant that would constitute harassment?
You could, Your Honor, but it doesn't equal harassment. Just the word rant does not equal harassment. And I don't think that there's anything in the record that shows that the plaintiff actually defined rant in real time or talked about what happened to him from that rant. And I'm talking about the inner, I know you've read the briefs, I'm talking about within the inner office in the exam room. So I really think that there
was no discussion about what was said in that office?
There was a discussion about what was said. And the plaintiff went into some detail about the fact that my client, Mrs. Sundaram, actually was talking about him, and we can only imagine that was to the doctor. It was about him. There wasn't any evidence that it was directed at him. And
does it have to be? I mean, I'm trying to be as specific as we can. But it doesn't have to be directed at him for harassment, doesn't it? I mean, it can be directed to other people as long as it's harassing to them.
I don't think that's what LaFaro stands for, Your Honor. I've spoken, we've discussed that in our brief. And in the LaFaro decision, the defendant was calling the plaintiff names, calling him a fascist and a Nazi, and it was to another person, and it wasn't directed to the person. And this court held that, the Arizona Court of Appeals held that did not meet the definition. And it has to be...
Was the person present there in LaFaro?
I think he was present, yes. He was present, but it wasn't...
Well, the statute just says anonymously or otherwise contacts, communicates, or causes a communication with another person by verbal, electronic, mechanical, telegraphic, telephonic, or written means in a manner that harasses and repeatedly commits an act or acts that harass another person. So I'm not sure why it just has to be someone else, but as long as a reasonable person would feel harassed.
Well, but in interpreting that statute, the LaFaro court held that it had to be directed at the person. And
but if you come, you can't just go to someone's house and take your friend and just talk to your friend deliberately, saying something that's offensive to the person that you're arguably harassing, and the fact that you're just saying it through your friend can't be the law, that somehow insulates you from any possible liability for harassment.
I don't think we have to go there, Your Honor, because I don't think that that's what happened in this case. But even if it were, I actually think you could if you just did it one time, I think you could be in a person's home. Well, I mean, that wasn't the situation here anyway. It was a public place, but you could be in a public place and you could be saying to somebody else, which is exactly what happened in LaFaro, and that's the case we're relying on. This was not an act of violence.
But this is not really a public place. When you are in a doctor's office with your child and somebody else is there, the other parent, that's not really a public place. We're there for a specific purpose, and there may be 3 people in the room, but it's not per se public. Would you agree?
I would agree with that. I was just trying to differentiate Judge Cantani's explanation of like a person goes to somebody's house. That just isn't the facts of this case. But let's talk about what happened in the inner office, Your Honor. The trial judge denied the trial judge sustained our objection to the reliance on that minute entry from another family law court. He sustained that. Oh, you were going to say something.
And I understand, and then referenced it when ruling, and I understand why that's a little inconsistent. But if we put that order aside, and 2 parents who are not cohabitating and not getting along very well go into a doctor's office to seek treatment for their child that has autism, what benefit is it to anyone if they're back and forth about what's going on? And I understand the trial court said in the family law matter, we're not going to do that. But in this circumstance, she is talking about his mental health. She is engaging with the doctor. She is engaging with him because he's in the room, and to things that have absolutely nothing to do with what they're there for.
Well, that's not clear. And first of all, I just want to correct the record because my client would want me to, if she were here. It's her understanding and belief that the child does not have autism, and that's not part of this record for this order. But that's another issue. I just wanted to correct it.
Okay.
But the minute entry itself, it isn't just that it's a little inconsistent. The judge literally sustained any reference to that court order. And then when he ruled on the order of protection, he, in denying the motion for new trial, he relied on that very minute entry. Even more troublesome, Your Honor, is the fact that the court actually said that, the court is was aware at the time of the hearing of this other minute entry in his order denying the motion for new trial. I believe that's highly improper. The other problem with all this is that there was never any evidence that what my client said, it was purportedly a rant. But other than that, there was no evidence that what she said was not in any way meant to harass the defendant or the plaintiff in this case. And when I asked her on redirect, did you do anything aggressive during the whole time of this, what happened here? She said no. And I said,
assuming there's nothing aggressive, couldn't it still be harassment even if she's not intending something?
No, not on. Okay, so the first thing that the judge ruled was that, what he ruled actually in real time was that it violated the repeated the A3 part of the statute. Okay, 13-2921A3. So that was the repeated. He ruled that the rant was repeated acts. There's absolutely nothing in the record to establish that. It was one rant, purportedly, just viewing everything in the light most favorable to the plaintiff.
And
but then
is one not enough if it's a really long rant? Would that?
I don't think so. It's a rant. And in any way, there's nothing to define what that constituted.
Stop the rant for a couple of minutes and then restart.
If that was in the record, yes, but that's not in the record. We can only go by what is in that transcript. in fact, Your Honor, this was a pre-issuance hearing, so this wasn't even a case where the plaintiff was granted an ex parte order of protection. And I think it may have been this very judge. We're trying to confirm whether it was or it wasn't, but it may have been this very commissioner. But a commissioner, this judge or otherwise, denied the order of protection for plaintiff and set it for hearing. So it's not like this was being affirmed. This was an order of protection that was being entered on literally plaintiff's testimony that mother talked about his mental health and talked about the fact that he was schizophrenic and about his profession, all of which were true, by the way. And I mean, if she was giving this information to the doctor because she's trying to figure, because this is important for the doctor, the court knows, I think, that because of the other appeal, this is a central issue in this whole case. Mr. Nicaise's mental health, and so she felt, if she felt it important, which she said, she testified that all of her actions were to protect the child and the safety of the child, and at no time was she being aggressive. So you have to assume the burden is on him to establish that this was done with the intent to harass.
Or knowledge. It's the statute reads intent or with knowledge that the person is harassing another person.
That's right. But she
She just knows that by continuing to make these statements over and over that she is harassing.
There's nothing in the record, Your Honor, with all due respect, that she knew that she did this over and over. She said to the doctor.
That goes back to the other question that was asked about. I mean, there is that where the judge sustained your objection. Yes. And that raises another question for me. What's the remedy?
Well,
I mean, if we have inconsistent rulings that go to the ultimate outcome,
well, are we
going to remand this after the order has expired?
I think it needs to be vacated. Absolutely. An order of protection is a...
Well, it's no longer in existence.
Well, it may not be in existence, but there's going to be, like, this case has now gone up to the Arizona Supreme Court. It's going to, may or may not be remanded. If it's remanded, whatever happens, mother is able to go back into court now and ask for modification. It's been more than a year since the ruling. So this, especially with the Brady ruling, which I'll get to, a judge could rule that this was a significant act of domestic violence, and yes, it's definitely prejudicial to her.
But no, that's not my point. I guess I wasn't very, very clear. If there's an evidentiary issue in an order of protection and it's up on appeal, what's the outcome?
The outcome is that
do we remand it?
Or you vacate.
Vacate and remand?
Yes, I think you have to. This is a case like any other case. We're a country of laws. I mean, the judge can't just say, I'm not going to rely on the minute entry, which the minute entry wasn't a reason for harassment anyway. So, and it was irrelevant, and the judge was correct in sustaining my objection. And then he ruled in denying my motion for new trial, and actually in his original ruling too, Your Honor, if you go back to the transcript, he ruled that part of the reason that he was issuing the order of protection against my client was because of this minute entry that had been issued, which the court was aware of. It was totally not in compliance with the mandates of what a judge is supposed to do. And you can ask for a new trial if there's error in the admission or rejection of evidence which here there was, or other errors of law occurring at the trial or during the progress of the action. That's one of the things we relied on. Or 6, that the ruling, decision, findings of fact, or judgment is not justified by the evidence or is contrary to the law. So yes, I think an error of law was made here. And let me just spend one moment on the Brady issue, because that actually takes this case from being a mere or run-of-the-mill harassment order of protection to a case where another court could eventually say, no, I'm going to rule that this was a significant act of domestic violence. And there is no reason that this Brady order should have issued at all. That was contrary to the law. This wasn't a threatened act of safety to him, to plaintiff at all. So I think that has to be vacated. And if the court has no other questions, I'll reserve my remaining time.
Thank you, counsel.
Thank you.
Good morning, Your Honors. I'm Carla Callahan. I represent Father in this case, and I don't have a lot to add to the briefs that were already submitted in this case, but I
Counsel,
did.
could you, let's take the last issue first. What evidence is there that would indicate this is a threat to your client that would warrant a Brady order?
As far as the threat, harassing can be threatening, and
But that's why I asked you, what is in there evidence that would show that this actually is a threat to his physical being?
as far as he took it as a threat, because she has done this numerous times on a harassing basis. He doesn't know what she's going to do from one moment to the next. So there was an order of protection against, the parties had dueling order of protections back in 2015, and the Brady was invoked in that one.
What was said, what happened at this incident that was threatening to him?
Just as part of bodily threat, no, there was not. However, harassing and that it could go further, that's where it became a Brady issue.
That could go further? That's the standard?
I think this judge in this particular instance had the parties on the stand, seen the demeanors of the party and both parties and how they acted. And with this history of this case, there is a problem in this case because it's highly litigated.
And where in the record does it say that the judge found that she represented a credible threat to the physical safety of Mr. Nicaise? Am I getting that right? Nicaise. Okay.
The judge did not say that.
Okay.
That
And
was not part of the testimony.
do you agree with me that that is a finding that is required before the issuance of Brady warnings or Brady restrictions?
I do, but I also think the demeanor of the parties and that the judge can go on and enforce some issues that may be.
But are you saying there's an implicit finding somehow, or doesn't there need to, don't we have to have some indication that the court made that finding?
Yes, Your Honor. Yes.
And you would agree on this record we don't have that?
That is correct.
Okay. Let's move on to the harassment issues now. If you will take up that portion of your argument, please.
Okay. I believe that it's what my client felt was harassment, a reasonable person, which he did, or he wouldn't have obtained the order of protection. He wouldn't have went down to the court and said, she is ranting. Ranting, he didn't use the word harassing. And it did go on for more than one sentence. It went on, or he wouldn't have obtained this. So that's why I believe that he was harassed, and it all stems from what he believed. If it was his...
Isn't it a reasonable person standard?
Yes.
That so you just one rant in a doctor's office, talking to a doctor, is enough? Does it have to be a specified length? Is there, if she just offers 3 sentences, is that harassment?
It could be. And it all depends on what he believed. And let's say,
Well, hold on, because I want to be clear or precise. Is it under A1 or A3 if it's in a doctor's office and there's a bunch of statements?
I thought A3.
It repeatedly commits an act or acts that harass another person?
Yes, because it is repeated. She doesn't say it just one time. She goes on and on and on. And just to, when I was thinking about preparing for this case, like a telephone call, I've had order of protections upheld over telephone calls just because it was at 2 o'clock in the morning.
Isn't that couldn't that be just A1?
It could, yes. But that's what I'm saying. It depended on what he believed.
Well, what did the trial court find? Did the trial court find A1 or A3? Repeated acts or one act that harasses?
Well, it was one particular day, but it was repeated.
But did the court make the finding under A1 or A3?
That I do not know, Your Honor.
And in your view, which provision could we affirm under?
I thought A3.
So it's a repeated acts, and it can just be, so 2 sentences, if you just repeat the same sentence twice, that's a repeated act that warrants a finding of harassment?
I believe it could be, yes. If it harmed him, if he felt it was harassing, if you say it more than once, it's
but if
repeating.
he's especially sensitive, and if it's a reasonable person standard, he felt it, but he has a history. Aren't we looking at this as just from a reasonable person standard, and 2 statements, 2 sentences, one after another, where they say the same thing? That's repeated acts that harass another person.
But in this case, that was just a for instance, but in this case, it was more than just 2 sentences. It went on, and as in a rant.
That repeatedly commits an act or acts. So you're saying that it can happen. Is there any kind of time limitation if this all happens over in a 1-minute time span? You can have repeated acts over a 1-minute time span of just saying the same thing for 1 minute, and that's going to be harassment under A3 or under 3?
If you don't stop, I believe it is harassment.
Is it repeated acts of harassment is what I think Judge Catani is getting at.
I believe it is, because it wasn't just one thing she said. It was about his medical license. It was about his mental health. It had different issues on what she was saying. So
we're going to parse. So now it can just be 3 sentences over a 30-second, but because each sentence deals with a different topic, then that constitutes repeated acts.
Well, when it was said more than once.
But Counselor, you don't need more than one. You don't need more than one. You can have an act
Correct.
that harasses, but just not under A3. An A1 could be an act or a communication.
Correct, which she did an act, but she repeated it. So,
But if we don't, and I can't speak for anyone else, but if assume 3 doesn't work, what's the evidence that that we could affirm under A1?
that it was said and that my client felt he was harassed, that a statement was said.
In a manner that harasses. So merely by stating it in front of someone else, that's a manner that harasses?
Yes. And I think we have to go, not that he's sensitive or anything, or if the statements were true or anything, but it's what he believed as a reasonable person. And that's why he did obtain this.
And that's 2 things. What he believed and a reasonable person standard are different, agreed?
Correct.
And you were saying that his understanding and his reaction is the same as would have been a reasonable person?
Because I believe he is a reasonable person on that, and it just seems like the statements that she made against my client, us being reasonable, we wouldn't like that heard or in front of others that she was making those statements. Okay. If you have no further questions, I don't have anything else.
Thank you very much,
Thank you.
counsel.
Well, Your Honor, we did, during the time that we were listening to the other side, to answer your question, 13-2921, Section E, literally says, for the purpose of this section, harassment means conduct that is directed at a specific person. So that directed thing that I was saying before, that prong that was spoken about in LaFaro, that's actually in the statute after all, and that would cause a reasonable person to be seriously alarmed, annoyed, or harassed. And the conduct, in fact, seriously alarms, annoys, or harasses the person. Your Honors,
So just so I understand your argument, so if you're saying she was not directing this comment towards husband, she was directing it to the doctor.
Correct.
So even though the child was present and the husband was present, it doesn't meet the statutory definition?
I don't think it does.
No matter how harassing we believe it
Well,
may be.
I mean, it could have been that harassing, Your Honor, but you got to meet your burden. It's just not in the transcript, and Your Honors have the transcript. The evidence, it's just not there, and even the trial judge in denying our motion for new trial stated that he didn't really talk about the definition of rant or what it did to him because of the time limitations. Well, that can't be the law. I mean, a trial judge can't just say, well, I'm not going to make him go into detail because, well, there were time limitations. And that's just not. It wasn't established in the record. And it wasn't established on the pre-issuance either. And it wasn't established in his petition. And, I mean, she testified, actually, that everything she did was done for the safety of her child. And she was at no time being aggressive. So she could have been talking, this is literally a he said, she said. It's not like there was a recording of this admitted into evidence. She could have been saying these things about his mental health problems, as we have written in briefs, and we've tried to educate the court. You know, this person is telling you things, doctor, but he's had his license revoked as a medical doctor. He's had been diagnosed before as schizophrenic. He has mental health issues. And she would have been acting as, coming to your concern, Your Honor, in trying to educate the doctor and saying, well, maybe he's saying such and such, but I have to tell you, he's got his own problems. And so you shouldn't.
Let's assume, though, that she's saying something that's completely untrue. She can avoid any finding of harassment by saying, well, I was telling it to the doctor.
You know, Your Honor, if that was in the record, I would say no. If it was in the record,
but now I'm trying to understand your position that if it's just if it's the content, you're suggesting that by talking to someone else, the doctor, that it changes the analysis. But if
it does.
Okay, but if it is something that's simply untrue, and then that starts sounding like a factual matter for the court to find, and that goes to kind of the way something is said and something that's better addressed by the trial court than by us.
If there was anything in the record to saying, well, if the plaintiff had sat up there and said, well, this is not true because I do have my
That
medical
could be
license.
untrue. If she's just communicating, isn't it an issue of fact of whether or not she's directing the comments towards the doctor or to her?
I think it is. I think it is an issue of fact, Your Honor, but I don't think that was met here. And the judge himself said it wasn't.
Couldn't you find, for example, that if you're going to make these kinds of statements, they shouldn't be made in front of the child and the husband, that you should talk directly to the provider or the healthcare professional?
That's a violation of a court order. There's a family court order in place that says, you should or shouldn't do that. And if that's an issue, you take it up down the hall with a violation of the order. That's an issue for maybe sanctions, but it's not harassment. I mean, that just can't be harassment, what went on in this record. And so I would urge the court to, if the court doesn't have any other questions, I would urge the court to vacate this and, yes, remand it back. It has tremendous implications for my client in ongoing custody litigation. And anybody can look this up and find that there was a Brady allegation made against her that shouldn't have been made.
All right, counsel, your time is up.
Thank you.
We thank you both for your arguments. We're going to take this matter under advisement. We will take a brief recess to prepare the courtroom for our next set of arguments.